Now in session, the Honorable Chief Judge Ural Glanville presiding. Court come to order.
All right, good morning, ladies and gentlemen. Please be seated.
Okay. Don't know who that is. Okay, Judge, I'm not sure if she's been here before. Another attorney out there.
All right, good morning, council's interested parties. We're on the record in the matter of the state of Georgia versus Cleef Adams et al. In 22 SC 183572. Mr. Stillwell, Mr. Botts, and Mr. Shard. Good morning, gentlemen. All right, Mr. Williams, Mr. Steele, Ms. Renard. Okay, good morning. All right, Mr. Kendrick and Mr. Weinstein, good morning. All right, Mr. Huey and Mr. Matthews Jr. and Senior, good morning. All right, Mr. Nichols and Mr. Lamar, actually Mr. Garner, I should say, good morning. All right. Mr. Ryan, and Mr. E. Williams. Good morning. All right. Ms. Hilton, Mr. Atkins, Ms. Love, and Mr. Brown. Good morning. All right. Okay, Ms. Renard, who's that interloper sitting to your left? And why was I not told anything about other people in my courtroom, Mr. Steele?
Good morning to you, sir. Your Honor.
Oh, don't be trying to get over that, man. You're already in hot water. So who do I have the pleasure of now being with you?
Your Honor, sitting next to Mr. Ryan and Ms. Renard is Haley Haltwanger, Haltwanger. She's a second-year law student at Georgia State University. I've had the honor of working with Ms. Haltwanger approximately 2 years. She's a fabulous lawyer, representing the next generation of lawyers, and with the court's permission, we'd like her to sit at the table. Mr. Adams means no disrespect to the court or Williams or anyone. He is not going to be here today. He is actually in another court the week on a trial. So can never replace Mr. Adams. I'm not trying to do that, but with the court's permission, that is who's in your honor.
Okay, Mr. Williams, you okay with that? Okay, all right. Okay. All right. Mr. Bean outside?
Yes, sir.
Your Honor, before we get started, I'd just like to ask if the court would allow us an opportunity to look at some certifieds that Mr. Steele indicated he has. He indicated he would show us the certified, and the court came in right before he had an opportunity to do so. So before we bring Mr. Bean, could we just see a copy of the certified itself?
Sure. You all can look at those.
Your Honor, would the court like for us to bring Mr. Bean in before I look at the certified?
No, why don't you accomplish that and then we can bring Mr. Bean in. I just want to make sure he was here, that's all.
Okay. And is it? Thank you, Your Honor. We have been able to look at a copy of the actual certified copy of 14 SC 130460. And based on information that Mr. Steele shared with me just now, I don't want to speak prematurely, but it appears that he also has some indictments that he intends to use. And I move in limine that the court preclude Mr. Steele from any attempts at impeachment or improperly introducing indictments that are not certified convictions of this witness or any other. Based on the information that he just gave me when I asked to see the certified copies of conviction, he has only given me one certified conviction for Adrian Bean, and that is for Fulton County Indictment 14 SC 130460.
Okay, so there's no argument about the certified, is that right?
Correct. There's
Okay,
no
all right.
argument about this.
And And what about the uncertified or do we, is that what you're asking me to,
Yes,
or to pose or weigh in on?
yes, because I've just been told that Mr. Steele has copies of indictments. I don't know.
You have certified copies of those convictions, sir?
And good morning again. As I told the district attorney's office, there's certified copies of charges of an indictment, not convictions. I told the district attorney I was not planning on seeking to admit them now, but they may become ripe. What happened in two different cases, if you want to know, is Mr. Bean was charged, serious crimes, armed robbery. I may be a little off here, but armed robbery, trafficking, marijuana, something to that effect. And the cases were dead docketed. Under Ridley, which is RIDLEY versus state, it's 368 Georgia Appeal 481. Your Honor, that's 890 Southeast 2D 385, 2023 case.
Question.
C the conviction. I have a digit. That's mine. But that's 157. Can I see 157C if you don't mind? Be certified. May I approach the?
You may, sir. Steele Westlaw didn't want to cooperate with this morning, but that's all right. Go ahead, sir.
I have a hard copy. I only have one though.
That'd be great. Thank you.
I apologize. I only have one
All right.
hard copy. Um, 481 is. May I approach, Your Honor?
You may, sir. Thank you.
May I, Your Honor?
You may.
Okay, so what the court in Ridley explains is that the confrontation clause, it's in the 8th paragraph, Your Honor, it's on page 2, and I've explained that to Mr. Brown of the state. The confrontation clause of the 6th Amendment guarantees to the accused the right to inquire about a witness's pending criminal charges in an effort to show that the witness has a possible bias, prejudice, or ulterior motive that may influence the witness's testimony. Whether the witness is testifying pursuant to a deal with the state is not crucial to the right to conduct such a cross-examination. And then, Your Honor, on the 2 items that I may not use, but that the state was inquiring about, and I just put them on notice of it. I gave them a thumb drive today, and I told them, is Seals, S-E-A-L-S versus state, 311, Georgia, 739. And it's in Division 3B, as in Barry Bravo, and specifically, Your Honor, if I may have the one copy, may I approach?
Yes.
A case is that Seals, that actually determined it. That's our case in Georgia that made this, that a dead docket case remains pending. So because the cases are dead docket, not null pros, they actually are pending with Mr. Bean, could be brought back on a live docket with the court's permission. The reason I said I gave it to the state, I just gave them everything. The reason I did that was in abundance of caution that it came up and I felt needed to do it. So I wanted to be courteous as you told me to do, and you told everyone to do. So that's why I did it. But as I told the state, I'm not really planning at this point to use them. They are older, Your Honor. I wouldn't be using them for impeachment. I think I'd be barred by the 10-year rule unless you made a finding that it was critical. But I can impeach with Mr. Bean with other convictions, so I can't really argue that it's, quote, critical to impeachment of this witness. I'm not saying the witness is not critical, but, you know, I have other manners and means to impeach him, I believe.
But he might open the door as to other things.
Exactly. And that's why I just did it at abundance of caution, but I'm not really there in my mind, but I just wanted to provide the state. I also gave them about 6 this morning. I gave them about a 10-minute interview that, you know, Honorable Investigator Jimmy Martin Jr., which is, it's really James, J-M-E-S, Martin Jr., and I did with Mr. Bean. It was Sunday, January 22 of 2023. And I will be using that for impeachment because, respectfully, I know it's a jury question, but I believe he was not straightforward on his testimony on direct last week. And it's also a prior inconsistent statement, but it also goes to trial testimony under oath, which can be impeached at all times. So I gave that to state early this morning. It's only a 10-minute interview. Okay.
Your Honor, 2 things I want to point out. Mr. Steele has had apparently this interview since January 22nd of 2023, if I heard him correctly. He did just send it to us this morning at 6 o'clock. That part is okay. The part that is not is that he would have to confront and lay a foundation for the playing of any audio recording that is out of court. Any such recording is barred as hearsay under 24A801 unless there is a, unless he can establish, unless he can confront, unless he can somehow establish that there is an exception to the hearsay rule for that particular statement. Secondly, the indictments that he has given us copies of, I believe for no reason should be allowed because they are way more than 10 years old. They are from 2011. He has, in addition to the certified for 14 SC.
Don't think that's the issue. He's just bringing them to the attention of you and the court so that if your witness should open the door as to him, I would make some certain probably findings at that point in time.
Yes, Your Honor, I understand. I, of course, do not intend to inquire into the defense's strategy, but for the sake of arguing that somehow there is a reason that this witness would want to cooperate with the state, that is what Ridley is intended to stand for. They would be able to show through open cases a witness's reason for wanting to cooperate with the state. And again, I would argue that these three, 11SC, 06SC, and 13SC cases for which Mr. Steele provided us indictments this morning are not permissible under any of those circumstances. And I, before he even tenders or walks to the witness to attempt to show them or even mentions them in front of the jury, I would ask that the court require Mr. Steele to, at the very least, outside the presence of the jury, tell the court what he intends to use them for. Because otherwise, once the toothpaste is out of the tube with respect to some impermissible document or impermissible item he wishes the jury to know about, it's already out. So I would ask that the court preclude him from even mentioning, tendering, or asking the witness about any 11SC case, 06SC case, or 13SC case that he has given us a copy of an indictment of for any reason until he, outside the presence of the jury, tells the court for what reason he intends to try and introduce it. Because again, we would argue that it's impermissible. It would be, as he stated himself, it's not permissible impeachment evidence. It is over, they are all over 10 years old. They're all closed cases.
But, well, they're dead docketed, right?
Okay, that's fine.
They're dead docketed. These two cases are apparently on the dead docket, right?
So the 11SC case and the 06SC case are either, they're dismissed for all intents and purposes. But the point is, and the 13SC case, let me make clear, I believe that one is actually states 157C. I believe he was sentenced for that one. So as far as if this is the same one that we've already introduced, we have no objection to that being used. But the 11SC case and the 06SC case were dismissed against Mr. Bean well over 10 years ago. And
Okay, all right. Were they dismissed? How were they dismissed? Were they placed on the dead docket? Were they null pros?
we don't have a
Where there's
certified
verdict?
copy of the file. So all that we have is a copy of an indictment with nothing more from the file from Mr. Steele.
So how do we know how it was resolved?
Because the copy of we don't know exactly how it was resolved beyond what Mr. Steele has shown us, which is the indictment itself with the word as to Adrian Bean, the counts are placed on the dead docket in July 2011.
Okay, well, they're
And I
placed
don't
on the,
know.
just stop. If they're placed on the dead docket, that case still is technically open. It can be prosecuted. And that's what the case law seems to
The
indicate.
statute of limitations has run on these items and we cannot, we've dead docketed it in 2011. We can't bring it back.
Your Honor, the statute of limitations is satisfied once the indictment is returned in open court by the grand jury. It's not a statute of limitations issue with a dead docketed count.
Again, Your Honor, since Mr. Steele has indicated that this issue is not right, my only request of the court is that before Mr. Steele mentions it, he, at least outside the presence of the jury, tells the court for what purpose he intends to try.
Let me ask a question. Mr. Steele, do you have some basis to believe that the state has offered Mr. Bean a deal or has indicated that they're not going to take these dismissed cases off of the dead docket? Or what's your theory of how you might confront the witness?
He would, no, to answer your question directly, no.
Okay.
I don't have any reason, good faith belief that the state is saying it's coming off the dead docket, but under Ridley, R-I-D-L-E-Y, that's not the issue. That's exactly why I gave you the case. It goes to the state of mind of the witness who is testifying. And the jury makes that determination.
The state of mind as to how?
Because what
Really doesn't say that.
Yes, it does. If you-
Where in really does it say that?
If
Point
you
to the
started-
page. I want to
if
see
you
it.
Started, the 8th paragraph, which I think is on the 2nd page, Your Honor, and then go to the 3rd page. And it says in the very top left-hand, I'm going by my memory, but top left-hand corner, it should say whether the witness is testifying pursuant to a deal with the state is not crucial. I'm going by my memory.
Yeah,
To the
that's
right.
pretty close. Okay.
To the right to conduct such a cross-examination. So it's a pending charge. This isn't about a deal. This isn't about conviction of 10 years of age. I just, got willing straight with the court. I'm just telling you, I understand that if it was a conviction, I wouldn't be able to use. I have other convictions for him, but they're over 10 years of age. I'm not trying to get those in because I don't think it's right to ask this honorable court to make a balancing test.
So you're saying he's still facing charges and that's
Exactly.
what you want to ask him about?
Yeah, that's all that issue is.
All right.
And it has nothing to do with the statute of limitations. It has nothing to do with a conviction. I'm just doing what I think lawyers should do. I'm just being straightforward.
Your Honor, under 403, given that these are dead document charges from 2011, and I don't believe that Mr. Field or Mr. Williams has any good faith basis to argue that under Ridley, he should be allowed to introduce this 11SC case and this 06.
That's what Ridley seems to indicate, and it tells me under 403, it's an extraordinary remedy which should only be used sparingly. So if he wants to ask him about he's facing charges, he's technically still facing charges and he would be permitted to do that. If it comes up, okay? So, but right now I would let him do that.
Well, with that being said, then I will do it.
Your Honor,
Okay.
under Ridley, when the court said that he was facing charges,
He's still facing charges. He's got a dead docket. Dead docket stops the statute of limitations. It's still open case. How many employments times have witnesses or other people faced dead dockets and then because the same thing, because it's still an open case? That's my ruling. Can we move on?
yes, Your Honor.
Okay, all right. If it comes down to it, so, yeah, he's got a good faith basis, so if it comes down to it, he can ask those questions. All right, anything else?
Not on behalf of Mr. Williams.
That's all, Your Honor.
Okay, all right. Sergeant Ingram, can you summon our jurors for us, please?
And Your Honor,
Madam.
Mr. Steele will not be attempting to play any hearsay. He won't be tendering any, is my understanding, without laying any foundation for that. Right.
All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. All right, ladies and gentlemen, good morning. All right, you sound good. Okay, all right. Ms. Love, I believe that we still have Mr. Bean with us, so can we summon him, please?
Yes, Your Honor.
All right. Mr. Bean, good morning. Come on up again. All right, sir, you're still under oath, okay?
Yes.
All right, thank you, sir. All right, cross, Mr. Steele.
Thank you, Your Honor. You were released from prison in approximately 2017. Is that correct?
Yes, sir.
And since you've been released from prison, you have been gainfully employed. You've been working, right?
Yes, sir.
And you work for, I believe, currently, and if I'm wrong, just tell us, for the city of Atlanta, is that right?
No, sir.
Who do you work with currently?
I'd rather not say who I work for, sir.
Okay, what do you do for a living? How about that?
I'm a foreman.
And explain what type of foreperson.
Foreman.
You said a foreman.
A supervisor.
Okay, for what type of work?
Traffic control.
Okay, traffic control. I'm sorry, I'm having a hard time hearing you. Traffic control?
The traffic control.
Okay. And how long have you been doing that?
I really can't recall.
One more time.
I can't recall, sir.
Has it been more than 2 years?
Yes, yes, sir.
Okay. And are you working other jobs as well currently?
No, sir.
All right. With regard to your testimony last week, Thursday and Friday, you said a lot of, I don't recall 2013. Do you remember something like that?
Yes, sir.
And I think you explained or tried to state that that was a bad time in your life, you blocked it out. If I'm misstating that, just correct me.
You don't recall anything from 2013, sir.
And why is that?
I just don't recall. I don't remember. I just don't recall, sir.
Do you remember things in 2014?
No, sir.
No? Yes or no?
No, sir.
2015?
I don't recall, sir.
How about 2016?
No, sir.
2017?
I just remember what I need to remember in 2017.
That's after prison, is that what you're saying?
I mean, I was released from prison in 2017.
And is your memory good after 2017 released from prison? Do you remember whenever month, I don't know the month, you're released from prison, you remember that? Is that what you're telling the jury?
Yes, sir.
And you remember then 2018?
Your Honor, I object as to vague. That's a broad question and not specific
Okay,
enough.
all right. I'll sustain the question. Just rephrase, Mr. Steele.
Do you have a memory of things you did in 2018?
Again, objection, vague.
I'll let him answer the question. I'm all over the question. You can answer it, sir.
2018. What I'm remembering in 2018.
You don't?
What am I remembering in 2018, sir?
Anything, where you were working, how about that?
No, I don't remember where I worked in 2018, sir.
Okay. Do you remember being home in 2018, not incarcerated?
Yes, sir.
All right. How about 2019? Same question.
What am I remembering?
Same question.
Every year you asking me, what am I remembering for every year that you ask me about about this certain type of year? That's what I'm trying to get you to understand.
Answer my question. Do you remember where you were working in 2019?
No, sir.
Were you working in 2019?
I don't remember.
Were you living free in 2019?
I'm free.
Were you living with your wife in 2019?
I've been with my wife in 2019.
Same question. It's 2020. You remember that year where you were working?
I've been doing the same job for some years now, so it'll run into all that. It's 24 now. I've been working by 7, 8 years now. The working part is gonna be what you asking me about, sir.
And you remember that in 2020, right? Yes or no?
Yeah.
And 21, same question. Remember
Okay, yeah.
that?
I remember my work 21. I remember my work 22. I remember my work 23. I remember my work 24. This year right now, what we're looking at.
How clearly do you remember 23 and 24 years? This year and last year.
Not too well.
I can't hear you.
Not too good.
Okay. Mr. Bean. You remember being convicted of what has been marked as State's Exhibit number 157C, as in Colette or Charlie, that you identified last week. Do you remember that?
No, sir. I don't know.
Okay. Your Honor, with the court's permission, may I show electronically 157C in Colette? And Mr. Kokomo, if you can help me out. It's already in evidence, Your Honor.
Yes, sir.
It should be on the screen. You can look behind you or right next to you in a moment. And I want to go through this with you. Okay, Mr. Bean, what's on the screen is been already admitted on March 1, 2024. This is the Superior Court of Fulton County, State of Georgia versus you. You see that on the left-hand side of that first page?
Yes, sir.
And you see where it says filed in the office of the Deputy Clerk of Superior Court, Fulton County. It gives the date of October 15, 2015.
It's gonna still be the same.
I can't hear you.
It's gonna still be the same. I seen this paper last week. The same paper Ms. Love showed me last week.
I just cannot hear you.
Friday. It's gonna be the same thing. I seen this paper before.
Answer my question. Do you see it says October 15, 2015, filed in the office of Deputy Clerk, Superior Court, Fulton County?
Yes, sir.
And you see in the next column to the right, there's a rectangle and it has your date of birth, June 22, 1979. True?
True.
Okay. And then if you go down on that page, with Mr. Kokomo's permission, you see it lists certain charges on the left-hand corner. You see that? Left-hand side? It goes from 1, 2, 3, 4, 5, 6, and then it skips to 9. You see that?
I see it.
Okay. And then it says in the disposition, you see 2 columns over, after it says charge, and then you see disposition.
Yes, sir.
And on count 1, it says guilty Alford. Right?
I don't know.
Do you see it?
I don't know.
I can't hear you.
I don't know.
Do you see it? Is what I'm
I can't
asking.
really see it.
Yes?
Okay. Where you thing at? Yes, sir.
Okay. And then it says for the sentence, 10 years to serve 3 years. That's in prison, right?
Okay.
Balance probated 7 years, right?
Okay.
And then it says concurrent with, and it gives another indictment number. You see that?
Okay.
And that's indictment number 14 SC 130460, which we're going to discuss in a moment. All right? Okay? Yes?
Hey.
All right. Now, this is October 15, 2015, and the total sentence here is 10 years, right?
I don't recall this.
Well, that was your sentence.
I don't recall this, sir.
Okay. This is the same document you recalled last week on the 1st of March, right?
I still didn't recall it.
All right. Count 2, you see on the left-hand side, count 2, it says aggravated assault against a police officer, vehicle on vehicle. You see that? You see that?
Yeah, I don't recall none of this paperwork right here, but you're showing me though, Mr.
All right, well, it's in evidence, so we're going to go through it. Again, you pled guilty under Alford, right? And the same sentence, 10 years is total sentence, 3 years in prison. The balance is 7 years on probation to run concurrent with count 1. Okay? That's what it says, right? Yes or no?
Sir, you got to answer the questions, okay?
Yeah, I guess it's on the screen. Yes, sir.
Count 3 is again aggravated assault against a peace officer. And again, guilty under Alford, 10 years to serve 3 years, balance 7 years on probation, concurrent with count 1, right?
I never pleaded to this.
All right, we're going to talk about it. We'll go through the whole document. The next one is count 4, 5, and 6, and that's armed robbery, aggravated assault with a deadly weapon, and possession of firearm during the commission of a felony, and all those were no pros were dismissed. You see that?
Yes, sir.
All right, and then the last one is count 9, fleeing or attempting to elude, misdemeanor, and again, guilty under Alford, 12 months to serve, concurrent, run at the same time as count 1. That's what it says, right?
That's what it says.
All right, let's go to page 2 with Mr. Kokomo's permission. And these are the terms of the sentence summary. You see that right there where Mr. Kokomo stopped? You see in bold, it says sentence summary.
Sentence summary, yeah.
Okay, and defendant is a word used for somebody charged with a crime, right? You know that?
I didn't know that.
Like a plaintiff is a state or a defendant is a person charged, or in a civil case. Do you know what I'm talking about?
No, sir.
No? Okay. Well, it says the defendant is a judge guilty. Excuse me, I'm in the wrong place. The defendant is sentenced for a total of 10 years, with the first 3 years to be served in confinement, the remainder to be served on probation, right? Then it says or, and that it's not checked, to be served on probation. So you were sent to prison, right? You see that?
You say so.
Well, that's the prison you're talking about with the jurors that you said you got out in about 2017, right?
Yes, sir.
All right. And then if you go down to the next line, the defendant, which is just the way it's termed, but you are to receive credit for time served in custody as determined by the custodian. That's the Department of Corrections for the state of Georgia, right? You see that?
Yeah.
And then on the next one, which is box 2, it's checked. Upon the service of 3 years, the remainder of the sentence may be served on probation, provided that defendant shall comply with the conditions imposed by the court as part of the sentence. And then it goes through general conditions of probation and special conditions underneath. Okay? You see that?
Mm-hmm.
All right. And then Mr. Kokomo can scroll down and it's checked, or X, number 2. Probation supervision fee is waived for the first 6 months after release. You see that?
Yeah.
And then on the next page, it says special conditions of probation. And you waive your 4th and 5th Amendment rights, meaning you have to answer questions, right? Do you know what the 5th Amendment is?
Your Honor, I object as to the commentary about having to answer questions.
I sustain the objection.
Do you know what the 5th Amendment
Your
is?
Honor, I'd ask
I
that.
sustain the objection.
For the 5th Amendment? Ask him if he knows what it means. Okay. You waive your 4th Amendment and 5th Amendment rights. You see that?
I'm looking at it.
Okay. And then maintain employment, undergo regular random drug screens, obtain a GED, and then back to that court if your probation is going to be revoked. You see all that?
I'm looking at it.
And revoked probation means you go back to prison instead of being out on the street under supervision of a probation officer, right?
I guess so.
You don't want to go back to prison, do you?
I mean, what do you mean?
cannot, I'm
What do you
asking,
mean, sir? Do I want to go back to prison?
you don't want to go back to prison, do you?
If I had to go, I would. I went to prison.
Do you want to go back?
I've been to prison before.
Did you enjoy prison?
Your Honor, objection.
I stand objection.
I mean, I did mine. I did my time.
Underneath that, if Mr. Kokomo comes down, you hired a lawyer, go down a little more, named Ed Adams. You see that by employment?
Yes, sir.
Okay. And then that court was the Honorable Judge Downs, who sentenced you. You see that?
Yes, sir.
Now, Mr. Williams never paid for any of your lawyers, right?
No, sir.
He never made any bond for you, right?
No, sir.
The next page of this document, 157C, as in Colette, Charlie, keep going down, is the indictment. I want to go through the indictment with you. Okay. If you go up a little bit. Perfect. Thank you, Mr. Kokomo. Go down just one more to get count 9. Now, on this indictment, Mr. Bean, in State's Exhibit number 157C, as in Colette, Charlie, you see the indictment number there in the center, written in 13SC122087. You see that?
Yeah, that's what it says.
And it says State of Georgia versus, and the first person is you, with count 1, 2, 3, 4, 5, 6, and 9. Same counts that we just discussed on the same page. See that?
That's what it says.
And then you have the next person charged is Walter Murphy. You see that name?
Yeah, that's what it says.
And he's the same Walter Murphy that you discussed earlier, according to, you said you didn't recall, but he was referred to by the Honorable District Attorney as DK. You remember that?
No, sir.
All right. And he is also charged with you in count 1, 2, 3, 4, 5, 6. Mr. Murphy's charged in count 7, but also in count 9. You see that?
That's what the paper says.
And then the last person is Frederick Medina, which is Medina, Prothro, Prothro. You see that?
Yeah, that's what it says, sir.
And Mr. Prothro is also charged in similar counts as you, but count 8. So he's charging 1, 2, 3, 4, 5, 6, 8, and 9. You see that?
That's what it says.
And this indictment was filed, if you go down a little bit, Mr. Kokomo. Originally, October 1, 2023. You see that?
It says 13.
You see that? Couldn't hear you.
I said it says 13.
Okay. And then for Walter Murphy, you see where he pled guilty to count.
Objection, Your Honor, as to having this witness testify about someone else.
I sustain the objection.
The documents and evidence.
It doesn't make a difference, Mr. Steele. That's a proper objection. I'm sustaining it.
All right. Let's just, before we leave this page, just go up a little bit, Mr. Kokomo. Show the jurors where Jeffrey Williams is charged, along with you, Mr. Prothro, and Mr. Murphy in this indictment.
You showed me.
I cannot hear you.
You can see it clear as day. It's on the paper. You showed me. He's not there.
He's not there. Now, October 1, 2013, the return of this case, that is after you spoke with Detective Quinn at the City of Atlanta Homicide Office on recording on September 17, 2013. You realize that?
No, sir.
All right, if you can scroll down, Mr. Kokomo. And Mr. Bean, this is the next page. And you see in the top, just talk about you. So I'm excluding the first column, Mr. Prothero, the second column, Mr. Murphy. We're going to the third column to the right on the top. You see where you originally pled not guilty with your lawyer, Ed Levance Adams, and your signature. You see that?
Yes, sir.
And that's, it says October 29, 2013. You see that?
Yes, sir.
And then if you go down and it's on an angle on the side, or actually it's on the center right, you see where it says Adrian Bean with your middle name? You see that in the center kind of right?
Yeah, that's what it says.
And you see there's a check mark, you pled guilty under Alford to the indicted offenses in count 1, 2, 3, and 9, like it says on the first page of 157C. You see that?
Yes, sir.
And that's October 1, 2015 now. So it's 2 years and 3 weeks after September 11, 2013 that you're resolving this case. You see that?
That's what the paper say.
More time.
That's what the paper say.
Okay. And then the other counts, if you look kind of on an angle, as to Adrian Bean, count 4, 5, count 4, 5, and 6 is null pros. Null pros means dismissed, just like was on page 1. You see that?
No, I don't see it.
Mr. Kokomo, can you just orient Mr. Bean? You see where that pointer is?
Okay, sideways.
And that's also October 13, 2015, right?
I can't really see it.
Yes?
I can't really see it. Yeah, I see it, man. At the bottom.
You see it? Yes?
I say, yeah.
All right. The next page of this document is the actual charges that you were facing along with Mr. Plethro and Mr. Murphy. And you see the names of the grand jurors in the center. It says a grand jury is selected, chosen, and sworn for the county of Fulton to wit, and they charge you. You see that?
You know, the paper say.
And count 1 charges you, Mr. Murphy, Mr. Medina, with the offense of aggravated assault against a peace officer for that the accused, that's you, and the other 2, in the county of Fulton, state of Georgia, the 11th day of September 2013, did intentionally drive and steer a motor vehicle at, towards, and in the direction of E. Robertson L., a peace officer employed by Atlanta Police Department as a peace police officer who was at the time of the said assault, engaged in the performance of his official duties as a peace officer, said motor vehicle being a means likely to cause bodily injury when used offensively against a person. You see that?
It's on paper.
Okay. And you were driving that 2004 Nissan Altima vehicle at the time that you almost killed Officer Robertson L., right?
I don't recall, sir.
Okay. You knew Officer Robertson L. before September 11, 2013, right?
I don't recall, sir.
And on this one count, you entered a plea under Alford, and we'll discuss what that means. 10 years to serve 3 years in prison, right?
Yeah, I don't recall it.
October 2015.
Yeah, I don't really remember anything.
All right, let's go to count 2. This charges, again, the grand jurors charge you, Mr. Murphy, Mr. Plethro, with the offense of aggravated assault against a peace officer. It gives a code section. You know what OCGA stands for?
No, sir.
You do?
No, sir.
Okay. For said accused, that's you, Mr. Plethro, Mr. Murphy, in the county of Fulton, state of Georgia, on the 11th day of September 2013, same day, did intentionally drive and steer a motor vehicle into and against the motor vehicle, which was then and there occupied by A.C. Booker Higgins, a peace officer employed by City of Atlanta Police as a police officer, who was at the time of said assault engaged in performance of his official duties as such peace officer, said motor vehicle being a means likely to cause serious bodily injury when used offensively against a person. You see that count?
And that's what the paper said.
And you pled guilty under Alford and were sentenced on that count, right?
No,
You didn't plead guilty
no,
to that count?
no.
Okay. Count 3. Grand jurors again charge you, Mr. Murphy, Mr. Plethro, with the offense of aggravated assault against a peace officer for said accused, county of Fulton, state of Georgia, on the 11th day of September 2013, did intentionally drive and steer a motor vehicle into and against the motor vehicle, which was then and there occupied by B. Porter, a peace officer employed by Atlanta Police Department as a police officer who was, at the time of said assault, engaging in performance of his official duties as such peace officer, and motor vehicle being a means likely to cause serious bodily injury when used offensively against the person. And you pled guilty to that and were sentenced, right?
I don't remember.
Okay. Count 4 is going to be no process against you, but the charge is that you, Mr. Murphy, and Mr. Plethro were charged with the offense of armed robbery, for that you all, county of Fulton, state of Georgia, the 11th day of September 2013, did unlawfully with the intent to commit a theft, take from the person and immediate presence of Derek Dotson, United States currency, the property of Derek Dotson by use of a handgun, an offensive weapon. That case for you was dismissed, right?
I don't remember.
Or no process.
I don't remember still.
All right. Mr. Kokomo, just go back to the very first page of State's Exhibit 157 for a second, please. And scroll down to count 4, 5, and 6. You see count 4, armed robbery we just read, and then it says in the third column, disposition, no process. You understand that? The same with count 5 and 6.
That's what
Right.
the paper says.
Okay. Let's go to count 5. What was dismissed against you? You were charged in count 5, along with Mr. Murphy, Mr. Plethro, with aggravated assault with a deadly weapon for said accused in county of Fulton, state of Georgia, on the 11th day of September 2013, did unlawfully commit an assault upon the person Derek Dotson by shooting at, towards, and in the immediate direction of Derek Dotson with a handgun, same being a deadly weapon. Your case was dismissed. That's what you would charge, right?
Yes, sir. The paper say.
And then count 6 is going to be the grand jury's charge you, Walter Murphy, and Mr. Plethro with the offense of possession of a firearm during the commission of a felony for that said accused, the 3 of you, in the county of Fulton, state of Georgia, on the 11th day of September 2013, did unlawfully have on and within arm's reach of accused person a handgun during the commission of a felony against and involving the person of another, to wit, armed robbery, and that case against you was dismissed, right?
That's what the paper say.
Okay. And then number 7 charges just Mr. Walter Murphy with possession of firearm by convicted felon. Count 8 charges Mr. Plethro, possession of firearm by convicted felon. And then count 9 charges you, Mr. Murphy, and Mr. Plethro with the offense of fleeing or attempting to elude for that said accused, county of Fulton, state of Georgia, 11th day of September 2013, did willfully fail to bring his vehicle to a stop after being given a visual hand signal to do so by E. Roberson L., a police officer employed by Atlanta Police Department in uniform, prominently displaying his badge of office in an appropriately marked police vehicle. And you pled guilty under Alford to that, right?
I don't remember.
The next page has again your name, your date of birth, has 6/22/79, and then Mr. Murphy and Mr. Plethro's information. And then if you go down to the witness list, you see the witnesses, Derek Dotson, and then the police officers, including Detective Quinn. You see that?
Yeah, that's the paper say.
Okay. Now, that same day, you disposed of another case. You remember that?
No, sir.
Your Honor, may I approach?
You may, sir.
May I approach you? I'm showing you what I've marked as dated today, Mr. Williams, number 199. You can look at the whole document, okay? I'm not trying to rush you. I mean, this is your signature.
No, sir. I didn't write that. I didn't write that.
Is that your signature?
I didn't write down one of them.
Is your lawyer, you recognize the signature of Ed Adams? That's your lawyer?
I don't know how his signature would be, sir.
Is that your lawyer?
Yeah, that was my lawyer, but I couldn't explain to you about his signature.
Do you remember being charged and convicted of aggravated assault with a deadly weapon for an incident on September 7, 2012? Did commit an assault by shooting a person named Cameron Randolph? Do you remember that? I can't hear you.
No, sir.
You deny it.
I mean, if that what the paper said, I don't remember that. I don't remember the name back then.
Do you remember being charged in count 2 with aggravated assault with a deadly weapon on the same day, September 7, 2012, by committing assault on James Butler by shooting James Butler?
No, sir.
You're denying that.
Yes, sir.
You do realize you're on an oath.
Yes, sir.
Remember count 3, being charged and convicted of possession of a firearm by a convicted felon on the same day, 7th day of September 2012, did knowingly and unlawfully.
I don't remember that, though, still.
You had a firearm, to wit a handgun. You were a convicted felon from indictment number 01SC03786, Superior Court, Fulton County, charged with possession of cocaine with intent to distribute on May 18, 2021. Are you denying that?
Sir, I don't remember that, sir.
And then on the last page, it has, again, your name, and your identifying information, including 6/22/79 as your date of birth, right?
That's what the paper say.
Your Honor, I have a certified copy of a conviction from the Honorable Fulton County Superior Court Clerk for State of Georgia versus Mr. Adrian Bean, same lawyer, same date, judge down, the plea colloquy if you want it. And in fact, I have the same date of birth on the document itself, and I move it into evidence.
Have you shown that to the state? What
Of
are you
course.
marking there, sir?
Mr. Williams, number 199.
Any objection to Mr. Williams 199?
State has no objection to the self-authenticating document that is the certified conviction. That is Williams 199. I'm not certain what the rest of Mr. Steele's representation is regarding a colloquy, but the certified conviction state has objection.
I'll admit, Jeffrey Williams, 199, the actual certified copy of the conviction. The other allied documents can be separated, okay?
Your Honor, may I approach Mr. Bean with Mr. Williams, number 199, that's in evidence, as well as states 157C, in case he needs to refer to them.
Yes.
May I approach you again?
I don't care. What?
Can I?
Yes, sir.
I'm showing you, and I'm going to leave with you, in case you need to see them, just let us know if you're looking at them. This is Mr. Williams, number 199 in evidence. This is State's Exhibit number 157C. Okay. With Mr. Kokomo's permission, Your Honor, I would like to show on display Mr. Williams, number 199, that's now in evidence.
All right, may be shown.
Okay, Mr. Bean, we are looking with Mr. Kokomo's permission at Mr. Williams, number 199. It's on the screen. It's also right in front of you. If that's easier for you, you could look at either one. And at the top of that, on the left-hand side, again, it is State of Georgia versus you, Adrian Bean. You see that?
Excuse me. Can I say something?
Not really. Answer my question, and then you ask the Honorable Court.
Is that what the paper say?
What'd you say, sir? I'm sorry.
That's what the paper say?
And then this is for indictment number. You see under it, criminal action number 14 SC 1306, 0460. You see that?
Yeah, that's what the paper say.
All right. And Mr. Bean, to the right of that, you see in that rectangle, it's the same date of birth for you, 6/22/79, right?
6/22/1979 has been stated to be my birthday. Yes.
Okay. And then underneath it, we are going to go to the charges. You entered a plea. It says a non-negotiated plea. You see that check mark right in the center top? Or it's not a check, it's an X.
That's what the paper say.
Okay. And then a little down, you're charged now in 4 counts in this indictment. And the first one is aggravated assault with a deadly weapon, as well as is the second count. The third count is possession of a firearm by a convicted felon, and the fourth count is possession of a firearm during the commission of a felony. You see that in the second column on the left?
That's what the paper say, sir.
And then in the center, well, it's center left, you see the disposition? You again entered a guilty plea under Alford to all 4 counts. You see that?
That's what the paper say.
And then next to it is your sentence. And you see the sentence now is 10 years to serve 3 years, balance of 7 years on probation. And that's to count 1 as well as count 2. You see that?
That's what the paper say, sir.
And then on the far right-hand corner, that says concurrent with the indictment number, which is in State's Exhibit number 157C, as in Collette, indictment number is 13 SC 12207. You see that?
That's what the paper say.
And then for count 3, and you get 5 years to serve 3 years, balance of 2 years probated. You see that?
Yeah, that's what the paper say, sir.
And that's concurrent with count 1 as well. Right?
That's what the paper say.
Okay. And then on the last count, it says 5 years to serve, suspended, consecutive to count 1. You see that?
Yeah, that's what the paper say.
And consecutive, you know, means run after, right?
I don't know what the consecutive means, sir.
All right, well, the sentence summary, if Mr. Kokomo goes down. The summary is that you, the defendant, is sentenced for a total of 15 years The first 3 years to be served in confinement, the remainder to be served. And then if you go to the next page, the very top, you are to receive credit for time served in custody as determined by the custodian. And then number 2 is checked. Upon the service of 3 years in prison, or upon the service of 3 years, the remainder of the sentence may be served on probation, provided the defendant shall comply with conditions of probation. And when you go down, Mr. Kokomo, they're going to be the same conditions that we discussed earlier for your other conviction in State's Exhibit 157C. You see that?
And that's what the paper said.
All right, and then if you go down to the date, keep going down, please. And there again, you're represented by your lawyer, Ed Levance Adams, by employment, and that's October, ordered the 14th day of October, 2015. You see that?
That's what the paper said.
The next page is going to be your indictment. And this is 14 SC 130460, charging you, Mr. Bean, with those 4 counts, 2 counts of aggravated assault, possession of firearm by convicted felons, count 3, possession of firearm during the commission of a felony. That was returned on October 24th, 2014. You see that?
Yeah, that's what the paper said, sir.
And underneath that, it is stamped there, October 24th, 2014, same day the grand jury returned the indictment. And if you go down, you had first, on December 22nd, 2014, entered a not guilty plea, and that's on the left-hand side with your lawyer. And then in the middle of that page that Mr. Kokomo is showing, you change it to a guilty plea under Alford versus North Carolina to all counts on the first day of October, the 15th day of October, whatever that says, 2015. You see that?
Yes, sir.
And then you see underneath it, it's filed in the office of the clerk of Fulton County Superior Court on October 15, 2015, the same day as you were sentenced on the other September 11, 2013 crimes, right?
That's what the paper said.
And then on the next page, it shows the grand jurors charged you, and then in count 1, this indictment is only you. You're the only person in it, right?
How many times we're gonna look at it?
One more time.
How many times we're gonna keep looking at the same paperwork?
You're the only one charged, right?
I ain't charged. I mean, how many times we're gonna keep looking at the same paperwork that you're showing me?
You're the only one charged. Answer the question, please.
That's what the paper said.
And then it says in count 1 that the grand jury does charge and accuse Adrian Bean with the offense of aggravated assault with a deadly weapon for that said accused, County of Fulton, State of Georgia, the 7th day of September 2012, did unlawfully commit an assault upon the person of Cameron Randolph by shooting him with a handgun, same being a deadly weapon. You see that?
That's what the paper said.
Count 2 that you pled guilty to under Alford charges you with the offense of aggravated assault with a deadly weapon for said accused in the County of Fulton, State of Georgia, on the 7th day of September 2012, did unlawfully commit an assault upon the person of James Butler by shooting him with a handgun, same being a deadly weapon. You see that?
That's what the paper said.
Now, this is approximately 4 days short of a year from then, is September 11, 2013, when you were driving that red 2004 Altima, right?
I don't recall still.
The next,
I don't recall still.
the next count is count 3, charging you with possession of a firearm by a convicted felon in County of Fulton, State of Georgia, on the 7th day of September 2012, did knowingly and without lawful authority possess a certain firearm, to wit, a handgun, accused having been convicted of felony on indictment number 01 SC 03786, Superior Court of Fulton County, charge of possession with cocaine. of cocaine with intent to distribute on May 18, 2021, right?
That's what the paper says, sir.
That's about 11 years earlier than September 2012, right?
I guess that's what the paper say.
And you told the jurors that you've been through the prison system several times. Didn't you say that today?
Today,
Didn't you say that?
I said I've been in prison before.
All right. And then count 4 charges you possession of firearm during the commission of a felony for that it says accused, excuse me, in the county of Fulton, state of Georgia, on the 7th day of September 2012, did unlawfully have on and within arm's reach of accused a handgun during the commission of a felony against and involving the person of another, to wit, aggravated assault, and you pled guilty to that, right?
I don't remember.
All right, and then on the next page, it shows the witness, it shows your name and information or some information, again, giving you date of birth as 6/22/79, and then the witness list against you. And you see that Mr. Billingsley, Mr. Butler, Mr. Randolph, and then those police officers. You see that?
Yeah, that's what the paper say.
All right. Now, Mr. Bean. I noticed several times on last Thursday and Friday that you were given a choice. Is your answer you do not recall information on statements that you gave on recording to Detective Quinn on September 17, 2013, or are you saying you did not?
Yeah, I didn't recall.
And you specifically never said that you denied that it occurred. You just kept saying, I don't recall. Remember that?
That's what I said.
Now, you know and remember September 11, 2013. The I don't recall is not true. You are not being honest to the juries. Am I right?
I don't remember, sir.
Do you recall meeting with me and investigator James Martin, private investigator, and we were trying to get in touch with you, and we caught up with you on Sunday morning, approximately 11 o'clock in the morning, on January 22 of 2023. You remember that?
Yeah, I remember.
You remember saying, because we were in front of your house, I'll speak with you, but let's go to the nearby Kroger. Remember that?
Something like that. I mean, I don't really remember the conversation, though.
Do you remember Investigator Martin and me asking if we can record the conversation with you?
Okay.
Do you remember giving permission and said, that's fine?
Okay.
Do you remember me telling you, I only want the truth?
Okay.
Do you remember?
Your Honor, as to this.
You have an objection, madam?
Objection as to
Basis?
hearsay, the questions have been posed.
I think he's gonna ask them, so at least, is that your intent, Mr. Steele?
I have to lay the foundation.
Your Honor, I'd like to approach us to the foundation.
right, ladies and gentlemen, it's not church yet. Come on now, stop fanning, all right? Okay, all right, not that hot. All right, ladies and gentlemen, we are gonna take a comfort break and then we're gonna go ahead and take lunch, okay? So we'll come back for 2 o'clock. We're gonna go about an hour at that point in time, and then that'll be the, we'll make I'll make some administrative announcements at that point in time, okay? All right, so remember the admonitions I've given you. Enjoy your lunch. We'll see you back at 1 o'clock. I should say at 2 o'clock, okay? All rise. Where you going? Oh my God, I enjoyed those immensely. Oh, I could have, they're like, I could have eaten those all afternoon. All right, ladies and gentlemen, please be seated. The door, Deputy, can you get Mr. Bean, please, sir? Thank you. Mr. Bean, just hold fast, stand fast. I'm gonna release you for lunch. Come back for 2 o'clock. I'll be back here just a little before 2. Don't discuss testimony with anybody except the attorneys in this case, okay? Okay, see you then. All right. Councils, we're gonna be in recess until 2 o'clock. Can I see Love, maybe Mr. Steele and Mr. Matthews? Can you all come up for a second, please? All right, we're in recess.
Yes, sir, everybody's here.
Thank you. All right, Mr. Bean, is he outside? Okay.
You want to come in?
Yes, please, thank you.
Your Honor, he's coming into the building. They told him.
Is that for you? I get, yeah, give him the box, give him the box, give him the box. I get the judge number.
All right, we're going to summon our jurors, okay? All right. Sergeant Ingram? All right, ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. All right, Mr. Steele?
Do you remember after driving the 2004 Nissan Altima vehicle into the side of the building, the laundromat, do you remember being arrested?
I don't recall, sir.
Do you remember that after being struck by the police car, you were then handcuffed and taken into police custody? Same day.
No, sir.
Do you recall then being taken to the hospital, Grady Hospital, for injuries?
No, sir.
I couldn't hear you.
No, sir.
You don't remember. Do you remember in Grady Hospital, a law enforcement officer, detective with the City of Atlanta Police Department coming out and speaking with you?
My statement was I don't remember nothing from 2013, sir.
Do you remember that while at Grady Hospital, this is before ever being taken to the Fulton County Jail, you spoke with that detective?
No, sir.
Do you remember the detective asking you questions about the incident involving the armed robbery of Mr. Dotson and almost killing police officer Robertson L. and striking the other police officer's vehicle and careening over the embankment into the wall and fleeing? Do you remember that?
No, sir.
Do you remember telling that detective, specifically Detective Lewis, at that time, that there were 3 people in the Nissan red Altima vehicle?
No, sir.
Do you remember telling Detective Lewis, or whoever the detective is, you don't have to remember a name, this is a long time ago, that the driver was not you?
No, sir.
Do you remember lying that the driver was not you and saying that the driver was your dear friend, Fred Plethro?
No, sir.
Fred Plethro and you are good friends, fair to say, or were good friends?
I don't recall, sir.
You don't remember stating that Fred Plethro is like your brother?
No, sir.
You've been arrested and indicted with Fred Plethro in the past, right? Not only the September 11, 2013 case, but other case, right?
No, sir.
You deny that?
Yes, sir.
To be fair to you, and maybe it doesn't need repeating,
I
I'm
don't
asking you
remember
to
no case from
Let me just finish speaking.
Fred Protocol.
Let me just finish speaking, then, or what did you say? I apologize. What did you say?
The same thing I've been saying.
Okay, I didn't hear what you just said about Fred Plethora.
I don't remember no case with him,
Okay.
being indicted with him. No, I don't.
Let me show you what I've marked as Mr. Williams number 200, exhibit number 200.
Your Honor, I'd like to object to this and I'd like to approach.
on.
Thank you, sir. Your Honor, may I approach Mr. B?
You may.
May I approach you, sir?
Sir.
Say yes.
Yes, sir.
Showing what I'd like to today's date, Mr. Williams, exhibit number 200. Take a look at that. Tell me if you recognize what is in Mr. Williams number 200. Recognize it?
I don't recognize none of it.
Okay. Your Honor, I move for the admission of Mr. Williams number 200, self-authenticating certified copy of the indictment from the Honorable Clerk of Court, Fulton County. Indictment number 11 SC 102083 for purposes of impeachment.
Any objection, Ms. Law?
No, Your Honor.
All right, it's admitted, may be inquired upon as you see fit.
Mr. Kokomo, thank you so much. All right, this is Mr. Williams on the screen. It's also in front of you, sir. This is indictment number 11 SC 102083. You see that in the center top part of this page?
That's what the paper says, sir.
And you see it's State of Georgia versus a gentleman, Mr. Frederick Prethrow, counts 1, 3, 4, 5. You see that?
That's what the paper says.
Then a William Herman Green with an E at the end. You see that?
That's what the paper says.
Also, Shadwana, if I mispronounce, I apologize. Shajuana Bean, same last name as you.
That's what the paper says.
And that's count 1, 3, and 4, right?
That's what the paper says.
And who is, if anyone, in relation to you, that person?
Objection, Your Honor. That's
Basis.
to relevance.
I sustain the question, remember what you asked him about, Mr. Steele.
All right. And then your name is at the end. See Adrian Bean, count 1, 2, 3, 4, and 8. You see that?
That's what the paper says.
Okay. And on the right-hand side, it gives the charges. You see that, 1 through 8?
Yes, sir.
Possession of marijuana with intent to distribute, possession of cocaine with intent to distribute, possession of firearm during commission of a felony, possession of firearm during commission of a felony, again, possession of firearm by a convicted felon, possession of firearm by a convicted felon, again, count 7, obstruction of a law enforcement officer, misdemeanor, possession of firearm by a convicted felon. You see that?
Yes, sir.
And then you see, you go to the, keep going to the right part of that page, it's written at an angle. You see that it says that upon the motion of the Assistant District Attorney, the within indictment is ordered placed on the dead docket, and the surety, meaning bondsperson, is relieved of liability in this case. This the 25th day of July, 2011. You see the judge signature, and that says as only to you. You see that?
Yes, sir. What the paper says.
Okay. And then on the next page, it has people's guilty or not guilty. On the next page, which will be the third page of this document, these are the charges that we just discussed. And I'd like to just look at,
Your Honor, I would object as to the presentation of the detail within the document.
Doc-
Improper impeachment.
documents in evidence, and it's a dead docket pending
Mr.
case.
Steele, same thing. She's objecting, it's without objection. Remember what you offered it for.
It's a dead docket.
I'm sustaining the objection.
Understood. Then turn to page, please, where it says, at the very bottom, witness list. Do you see that?
Your Honor, once again, I object to Mr. Steele getting into the specific that he's
I
trying to
sustain the
explain.
objection.
He's still on the
No.
Your Honor,
display.
I am showing that a witness in this case is Officer Robertson L. I'd like to impeach the witness that he didn't know who that was.
Your Honor,
That's not what you offered it for, so I'm going to sustain the objection. Remember what you told me you were going to offer, what you offered the document for. I'm admitting for that reason and that reason only.
Okay. All right. Mr. Bean, does this change your testimony in front of the jury that you've never been charged or indicted with Mr. Frederick Prethrow again? Or besides the September 11, 2013 case?
The document you show says that, I don't remember.
All right. And Mr. Prethrow was a close, dear friend of you in the early 2010, 11, 12, 13 period. True?
Your Honor, I object to that compound question.
I sustain as to form. You can rephrase, Mr. Steele.
You considered Mr. Prethrow a close friend in year 2011, right?
No, I didn't, sir.
2012,
No, I didn't.
2013.
No, I didn't, sir. I didn't remember.
Did you say
Go
something?
ahead.
Did you say something?
No, sir.
Did you remember telling, and did you tell Detective Quinn on September 17, 2013, that Fred Prethrow was like a brother to you?
I don't remember any questions that I had with a Detective Quinn, sir.
Do you remember telling me and Investigator Martin on January 22, 2023, that Fred Prethrow was very close to you?
I don't remember that either, sir.
Why did you tell the detective with City of Atlanta Police Department homicide at the hospital before you go to the Fulton County Jail?
Your Honor, I
On
object to
basis.
that's not an evidence, and I really object to that. This is asking a witness about something that isn't an evidence and will not.
It's his statement, Your Honor.
Your Honor,
I'm
there's,
going to overrule the objection. Let me ask the question, okay? We'll see where it goes from there.
Why did you tell the detective at the hospital, Grady Hospital, on September 11th, 2013, that it was not you, but your dear friend driving
Your
that
Honor, I
Nissan
object.
vehicle?
There are no facts that are in evidence. There will be no statement put in evidence.
That-
So I object to facts not in
Did
evidence.
he make the statement, Mr. Steele?
Yes.
Mr. Steele does not have any such statement. And there is no evidence that will say.
Can I see it?
Yes, sir.
Let me ask it this way. Do you have a good faith basis?
Yes, sir.
All right, I'm going to overrule the objection.
Do you remember at time of 44 minutes, 56 seconds on September 11th, 2000? That's wrong. That's wrong. I apologize. Do you remember on September 17th, 2013, on the recording with Detective Quinn at 44 minutes and 56 seconds, telling Detective Quinn that, yes, sir, I lied to the detective when they first came and talked to me, and I told them, and that's probably the lies you're talking about. I told them Big Fred was driving, and I was the driver. Big Fred was the passenger. Do you remember saying that?
No, sir, I don't remember that, sir.
Why did you tell Detective Quinn on recording at that time, stamp that I just said, that your dear friend is driving the car that almost killed a police officer?
I don't recall that, sir.
Why did you tell Detective Quinn that you typically use your cousin's name when getting arrested so you don't get arrested and they pull up your history?
I don't recall that either, sir.
Why would you use a cousin or any other person's name so you could get out of trouble but get them into trouble? Why would you do that?
I don't recall that either.
When at the hospital,
Your Honor, I object to the hospital statement because that is the part that is not in evidence and that will not come into evidence.
Is there a statement?
yes, sir.
Show that to Miss Love. You have a good faith basis, that's fine.
I sent it to Miss Love this morning before 6 o'clock a.m. It's a 10-minute recording.
It is not a statement at the hospital. It is a statement with Mr. Steele in 2023.
Mr. Bean admits to making that statement at the hospital. This is all proper.
And you probably need to orient him to before you ask that question.
Okay. Your Honor, can Mr. Kokomo come forward with headphones, play the 10-minute recording for Mr. Bean then?
I think you need to ask him some more questions in order to do that.
Okay. Do you remember having the ability to make a phone call or phone calls from the hospital from non-recorded lines to your wife, Courtney Bean?
I object to facts not in evidence. There's, as Your Honor.
I stand the objection. Why don't you lay a little more foundation, sir?
Have you, when you were prosecuted for this case that you're here about driving that you pled guilty about driving you pled guilty under Alford for driving the vehicle, almost striking the police officers. We discussed that in 157C State's Exhibit. That's what I'm talking about, okay?
Yeah, that's what
Answer
you
for the
saw.
record.
You
You
understand
have to
what?
answer for the record, okay?
Yeah, I'm
All
out.
right.
You
Yeah,
understand?
I seen some on paper, but I don't remember.
Okay. On that case, before going to Fulton County Jail, you went to Grady Hospital. Remember telling me that? And Jimmy Martin Jr. on recording?
I don't remember any conversation we had, Mr. Steele.
And it's me. I'm confident it's not you, so I apologize, but I can't hear you. I know you said you can't remember, but then there were other words. Can you repeat?
What was
what
your
you-
name? Mr. Steele, right?
Yeah.
Yeah, that's what I said.
What did you say, though?
I don't remember any conversation me and you had, sir.
Okay. Do you remember on Sunday, January 22, 2023, approximately 11 o'clock a.m., listening to a jail call that Jimmy Martin Jr. played for you in my presence at the Kroger restaurant near your, Kroger grocery store near your home?
I don't remember any conversations I had with you, Mr. Steele.
Do you remember at that Kroger restaurant, Kroger grocery store near your home on the same date? You're all gonna be the same date. Sunday, January 22, 2023, approximately 11 a.m. Jimmy Martin Jr. and I introduced ourselves to you, and I made it known that I represent Mr. Jeffrey Williams, performer known as Young Thug, in this pending case. Do you remember that?
I don't remember any conversation we had, sir.
Do you remember being asked your telephone number by Investigator Martin and giving him a number? I'm not going to say it except for the last four numbers, 0730. Do you remember that?
No, sir.
Do you remember being asked by Investigator Martin your date of birth and giving it as June 22 of 1979 and stating that you're 42 years of age?
No, sir. I'm
Do you-
44, sir.
Well, today you're 44. How old were you on January 22, 2023?
I was 43 then, I wasn't 42.
Do you remember me asking you is it okay for Investigator Martin to record verbatim our communication there at the Kroger on the same date, approximately same time?
I don't remember the conversation we done had, sir.
Do you remember explaining that Dirty Red, or a gentleman known as Derek Dotson, was a good close friend of you?
I told you that.
One more time.
I told you that.
Do you remember that?
I don't remember that either, sir.
Do you remember explaining that Fred Prothro and Walter Murphy, DK, I'm saying, were with you on September 11th, 2013?
I don't remember that either, sir.
Do you remember explaining that you were never charged with any crime involving Derek Dotson or Dirty Red? Do you remember that?
I don't remember that either.
And if you look at State's Exhibit number 157C as in Colette or Charlie, it's in front of you. You see that document?
Yeah, I seen a lot of papers that you presented, but I don't remember none of them like that.
Okay, well, look at the State's Exhibit number 157C. It's right in front of you. You see it?
Which one is 157C, ma'am?
One more time.
Which one is one?
Your Honor.
Okay. Want me to
And
look at it?
you can look at it. It's in evidence. And the charges against you by the grand jury were dismissed as to anything involving Derek Dotson, like you said, on January 22, 2023, correct?
I don't remember.
Do you remember explaining and talking about that entire incident involving Derek Dotson, Fred Prothro, Walter Murphy, driving, careening into the side of the laundromat, that Jeffrey Williams, or Young Thug, or Thug, was not involved in any way?
I don't remember the conversation, sir.
Do you remember then explaining that they, meaning the detectives, tried to force Jeffrey Williams or Young Thug into it? Remember saying that?
I think that was something you said, right?
No.
I don't remember that.
Okay. Do you remember explaining that the police wanted Thug in it and there was a lot of, quote, hype on the street?
I don't remember, sir.
Do you remember again emphasizing that Jeffrey Williams or Thug or Young Thug was not involved in any way on September 11, 2013?
I don't remember the conversation, sir.
Do you remember me referring to that jail recording between you and your wife made from the Fulton County Jail? And I asked you, what did it mean when you said, quote, they gave us a story to tell? Remember that?
No, sir.
Do you remember explaining that what you were referring to is that at the hospital, the police were telling us to lie, put Young Thug in on it, or face a lot of time in prison? Remember saying that?
I don't remember the conversation.
Do you remember explaining that you were the driver of that 2004 Nissan Altima vehicle, red vehicle, on September 11, 2013?
I don't recall.
But explaining that the police wanted you to make Young Thug the driver. You remember that?
I don't remember, sir.
Do you remember explaining on January 22, 2023, that you told the police on recording that Jeffrey was involved in this crime because you wanted to serve less time in prison?
No, sir.
Do you recall explaining that you made calls from the Fulton County Jail that you knew were being recorded to support your lie to the police that Jeffrey was involved on September 11, 2013?
No, sir.
Do you remember again emphasizing that Jeffrey Williams, I call him Jeffrey Williams, thug, whatever you call him, was not involved at all with this crime?
I don't remember, sir.
Do you remember explaining that Derek Dotson died, God forbid, before your case came to the court, and therefore all the cases involving Derek Dotson were completely dismissed as to you? Remember that?
I don't remember, sir.
Do you remember explaining that you got 3 years to serve in prison for shooting 2 people in addition to this case?
I don't remember the conversation.
Do you remember explaining that you are not involved with any criminal street gang and that September 11, 2013 was not criminal street gang activity? Remember that? Basis.
Assuming that's not an evidence, Mr. State.
That's what he said on recording.
I'll rule the objection.
Do you remember saying that?
I don't remember still.
And Your Honor, I also object as to compound, because we don't know which question you were answering.
I'll refer, I'll sustain it as to form. You can rephrase, Mr. Steele.
Do you remember explaining that you are not a part of YSL if it is a criminal street gang?
I don't remember, sir.
Well, are you part of a criminal street gang?
No, sir.
Do you have any tattoos of gang activity?
No, sir.
Do you remember explaining that you only know Thug, Young Thug, Jeffrey through radio and seen him in the neighborhood?
Yes, sir.
Do you remember again stating that Young Thug was not in any vehicle with you?
Your Honor, I ask that the witness be oriented as to when and.
So
where.
what's the objection?
The objection is to form the question.
All right, I'll sustain the objection. You can rephrase, sir.
Do you remember explaining again on January 22, 2023, on recording to Investigator Martin and myself at the Kroger's near your home, that Young Thug was not in any vehicle on September 11, 2013 with you?
I may have, I don't remember the conversation though still.
Do you remember explaining that Young Thug, who I call Jeffrey Williams, never directed you to commit any criminal activity?
I don't remember.
Do you remember explaining that on the street, everybody wants to go against the man? They want to go against Young Thug. He's got the money. Remember saying that?
Your Honor, I object and ask that he orient the witnesses.
I sustain as to form.
Do you remember on Sunday, approximately 11 to 11:22 at Kroger's near your home, stating on recording to Investigator Martin and me that the street wants, everybody wants to go against the man, Young Thug. He's got money. Remember that?
I may have said that.
One more time.
I may have said something like that.
Do you remember explaining that all you know is that Thug is in the studio?
I may have said something. I don't remember though still.
Do you also remember giving your opinion that Derek Dotson killed himself? This is a 10-year-old matter and this should be over with. You remember saying that?
Something like that.
When you were prosecuted for what's in State's Exhibit number 157C as in Colette or Charlie, when that case was prosecuted, you received what's called a sharing of information or discovery. You and your lawyer from the state of Georgia. Remember that?
Never received one, sir.
Okay. Do you know whether your lawyer received one?
Objection is speculation.
If you know.
I'll rule the objection.
I
Answer
never
the
seen a
question.
discovery.
I cannot hear you.
Seen had a discovery.
Have you ever seen any of the memorandum, recording, note of your meeting with the detective at the hospital on September 11, 2013?
Objection, assuming facts that are not in evidence. There's no good faith basis for that. There's no such interview.
You all come on up. Come on. Chris, you have to get some more tape. She's coming, coming off. All right, ladies and gentlemen, we got to take up some other things. And so what I want to do at this point in time is go ahead and recess for the day, okay? So, Mr. Bean. I need you to be here for 10 o'clock on Wednesday, March the 13th.
Yes, sir.
10 o'clock, Wednesday, March the 13th. You good with that?
Yes, sir.
Okay. As I mentioned earlier, don't discuss your testimony with anybody except the attorneys in this case, okay?
All right, 10 o'clock. Yes, sir.
All right, we'll see you then, okay?
Yes, sir.
Okay. Okay. All right, ladies and gentlemen, jury, let me go ahead and take up a couple of things with you, okay? As you know, we are going to be in recess tomorrow through next Tuesday. So that's the 5th through the 12th. So we good for that? Okay, now, I share with council that I'm in receipt of some correspondence from you about that you've taken an unscientific poll amongst yourselves, not in violation of the court's admonitions, but to ask about spring break and parentage and other things. Is that right? Don't be bashful now. Come on now. I got paper, okay? So have a good faith basis asking you this, all right? So is that your desire between the 1st and the 5th of April to be down? I think a majority of you wish for that to occur?
Yes.
Okay, all right. I've talked with our lawyers, and I think that would be appropriate, okay? So I wanted to address it to you now because I know you all want to plan, all right? But don't ask me for nothing else, okay? Nothing. Okay, all right, as long as we're good with that, okay? No, I'll do it, and I think it's appropriate for you all to be able to spend that time with your for those of you that have school-age children and the like. So we will be taking up other matters during that particular period of time, okay?
Yes.
Fair enough? All right. There's another person that sent me a note talking about the 20th of March. Don't identify yourself, okay? But I feel on pretty good authority that particular morning, you will be able to make that appointment that you need to make. But I've told all of you, please make your appointments I think I give you enough time so that we don't have any, kind of discrepancies with this as much as we can do it. Okay. So, try as much as you can. I mean, I know life happens. We'll flat on that and we appreciate that. But to the extent that you can, make your appointments or on the other days that will be kind of down or have administrative time, please go ahead and do so, okay? So, huh?
In recent, a couple of us have been getting some pushback. You know, you have been giving us notice.
Pushback from who?
The doctor's office. Some of them are booking out like 8 weeks out.
I understand that, and we'll work with you, okay? I understand that. I'm giving you a hard time, but to the extent, that you can, please do so. But we'll do whatever we can with that, okay? But if you can, what I'd rather you do, if you do have an appointment, make it first thing in the morning or as late as you can in the afternoon, so we can go ahead and take some. I can release you earlier, have you come in late, okay? So to the extent you can, I mean, as I tell people all the time, life happens, and then you do your various vocation. So we'll do what we can for that. All right? Okay. All right. So Do I have any ministerial inquiries of me at this point in time? Now that I've addressed the spring break and other appointments, and we'll just, like I said, we'll deal with them as best we can. Okay. All right. Anybody else have any other inquiry, question? You sure? All right. Okay. All right, ladies and gentlemen, unless you have anything else of me, what I'll do is at this point in time, I'll give you the customary ad nauseum admonitions for the period of time that we'll be down. And that is leave your notepads in the basket. Go ahead and take a juror sticker so you can take one and have one. Please do not discuss anything else that you've heard about the case amongst yourselves as you are going, no matter where you're going and who you're with, small groups, ones, twos, at home, at any other place you may find yourselves. It would be a violation for you to do so, okay? The other thing, ladies and gentlemen, is please do not consult any outside sources, books, the internet, or any other reference materials. Do not go by and visit the scene anytime or involving anything that we may have talked about here in open court. And remember, the only thing you can lawfully consider is what's presented to you in the four walls of this courtroom, all right? So with that, and also if anybody, as you know, tries to discuss this case in your presence or hearing or approaches you, you need to let myself or Deputy Ingram know immediately. And also please resist the temptation of listening to any news reports, podcasts, or any other third-party sources that may reference or chronicle this trial in any way, because remember, the only things that you can take up or consider are what is presented within this courtroom. So, I know that the temptation is great. Well, let's see what the lawyers and the judge are doing. No, that would be a violation. And remember, I told you that the way, how do we find out about these things? Y'all tell on yourselves. Yeah, you squeal on yourselves or you squeal on one another. So let's not do that. You all have been really good. So just continue to follow my admonitions, okay? All right. Do you have anything else, ladies and gentlemen, of me?
Are we supposed to report at 10 on the 13th as well?
Yes, ma'am. At 10 o'clock. Yes, 10 o'clock for 10 o'clock on the 13th of March. That was the first question. I saw another couple hands go up. Sir.
Same question.
Anybody else? All right, you sure? Okay, all right. All right, ladies and gentlemen, then we will see you all next Wednesday at 1000 hours, and we'll see where the day leads us at that point in time, okay? All right, we're in recess. All right, ladies and gentlemen. Okay, ladies and gentlemen, please be seated. Our jury has left us. Counsels, I will include, or you're welcome to take a look at these notes. I'm just not going to make them for public discernment. I will seal them in reference to our jury that has a doctor's appointment, as well as the unscientific poll that the jurors have taken. Okay, so you're welcome to take a look at them. I'm going to give those to Ms. Weaver, and they'll be sealed for purpose of record. Okay. The other thing, ladies and gentlemen, as I mentioned earlier, and we'll talk about it a little bit later, but the first of, and I had a bench conference with representatives from the state, Ms. Love, and also Mr. Steele and Mr. Matthews in regards to that week that the jurors are going to be down for their children that are in Atlanta system, Fulton County system, as well as that particular week of starting the 1st of April. It's the court's pleasure for us to take up Monday, the 1st, and/or Tuesday, the 2nd, any outstanding motions that may be had at that point in time. So block your calendars for 1 April, 2 April, that's Monday and Tuesday. And the court is going to give you a little bit of a administrative pause for the rest of the week, okay? But to the extent that we can, I know Mr. Steele's got a couple of motions that I need to take up at that point as well. So, all right. Any questions of me? Anyone? All right. Okay, so folks, all right, as to the ministerial, as to the scheduling. Okay. Since our jury has left us and it's advocates and clients and the court. The last thing that we were talking about at the bench was in reference to conversations that were supposedly made by Mr. Bean at the hospital. And I believe that we are in disagreement as to a couple of things. One, whether or not the statement was made referencing an event at the hospital. So I want to say that in order to seek ground zero on that, we'll have to let Ms. Weaver prepare or at least the transcript in reference to the testimony of Detective Velasquez in regards to his testimony on this particular statement made by Mr. Bean's statements. Okay, that also may have to be cross-referenced along with the interview of Mr. Bean, as well as the purported statements that were made to Mr. Steele and his investigator. So, counsels, I'm going to let you all kind of take a look at those three sources and be prepared to kind of talk about those when we come back on the 13th to see whether or not, in fact, that is, if we've been able to find some particular granularity on those particular statements and in terms of whether or not this particular conversation was had at the hospital or not.
Your Honor. And Your Honor, I have, if we will address this on the 13th, we can do that. I will be presenting to the court statements that were made by Detective Lewis, and of course we'll wait.
Detective who?
Well, Detective Lewis stated that when she went to the hospital, there were 2 males there.
Okay, so we'll need her testimony as well.
Right. I can give the court the statement that she gave.
Oh, I'll the statement or the transcript, the testimony.
She has not testified yet.
Okay,
She has not testified, but Detective Velasquez referenced her going to speak to Frederick Prothro and Walter Murphy. And then after she came back to the homicide office, after she came back from speaking with Murphy and Prothro, when talking to Brian Taylor Ransom, they learned that the car had been loaned out to Adrian Bean. So on scene, they did not know what, if anything, Adrian Bean had to do with the incident that occurred over in Summerdale. And Adrian Bean.
Okay, but the issue we're trying to create granularity on is whether or not Mr. Bean was taken to the hospital, whether or not he made statements from the hospital. That's what the genesis of you all's discussion is, or was it up here at the bench?
That's right.
So can we focus on that? That's what you objected to, because you said there's no basis for him. Right. And Mr. Steele says, well, this is what he told me in the taped interview I had with who's your investigator again? Mr. James Martin Jr. So that's what the contention is.
That's the base, and that is the basis for the objection, because Adrian Bean never went to the hospital, and I was only.
Okay, well, this is, we could, I mean, he might have lied. I mean,
To them, yes.
yeah, I mean, and that might be the truth. I mean, he lied about it. So, but whether or not that happened or not, I mean, I want you to, I know Mr. Steele wants to know whether or not that is true or not, because he certainly doesn't want to present any untrue testimony to the tribunal. But if he has another good faith basis that he was actually at the hospital, that's what I want you all to find out.
Yes. Your
Mr.
Honor.
Steele, I think you need to find that out, sir. Whether or not he did in fact, because you can't also, I know you would never do this. You cannot tell a witness something that you know is not true either. So, and I know you wouldn't do that, but I think let's just find out. Because if, I mean, there's any number, a couple scenarios that might have occurred in this situation. So I'll let you all figure them out.
Yes,
Okay.
Your Honor. Thank you. We
All
will,
right.
yes, Your Honor. Thank you.
Okay. Mr. Steele, want to add anything?
No, sir.
All right. Do either counsel want to add anything about the conversation we had at the bench in reference to our administrative pause in terms of our jury? You didn't know what I was talking about, right? No. I was asking Ms. Love about, do you want to add anything in reference to our conversation up here at the bench about the administrative pause?
No, Your Honor.
Okay.
We're just fine with that.
All right. Okay. All right. Okay. Any other ministerial or any other things I need to take up?
No.
Okay. All right. So you all figure that out, and then I'll take it from there on the 13th in regards to Mr. Bean's statement. Okay.
Yes, Your Honor.
All right. Okay. Unless there's anything else, councils, we'll see you all on the 13th of March at 10 o'clock. Okay. All right. We're in recess. All right.